How is it cool to point a gun at an 8-year-old boy? The bullet went in through Michael's upper arm, then passed through his neck.
It was not an accident when during the course of an argument, this defendant drew that handgun from under the seat.
Danny Ray Beard II and Andrea Washington were once in a relationship that later became unstable. In the weeks leading up to September 2018, Washington reported escalating problems and sought legal protection. She filed a police report describing threatening behavior and requested a domestic violence protective order, which a judge granted temporarily. She was found inside her Jacksonville home. Investigators determined her death was a homicide and began examining evidence from the scene, including digital and location data, which contradicted Beard's initial claims and placed him at the residence during the critical time. Following the investigation, Beard was arrested later that year and charged with second-degree murder. The case moved slowly through the court system until 2023, when Beard entered a guilty plea as part of a negotiated agreement avoiding a trial.
Yeah, I struggle with grief, despair, anxiety, uncontrollable crime, fearfulness, anxiousness, isolation, and other mental health disorders. Our family never thought in a million years that we would lose Andrea in such a horrific way.
This is a call that haunts me to this day. We didn't know what to do next. What do you say to the sailors whose cherished chief was just murdered?
Family members and fellow sailors spoke about her character and service, while Beard apologized for his actions.
I just want to give my apologies to the family for the heartache and pain I put them through. I just want to ask them for forgiveness.
Beard was sentenced to 30 years in Florida State Prison, bringing the case to a close and marking the end of a long legal process. Khalil McCoy was a 20-year-old woman from Jacksonville whose life was cut short in 2011. After spending time out one evening, she was riding in a vehicle with several people, including her former classmate, Frederick Lee Wade. During the drive, a dispute occurred, and McCoy was later found deceased in a wooded area. Investigators determined her death was the result of a criminal act, and Wade was charged with second-degree murder. In the first trial, a jury found him guilty, and he was sentenced to life in prison. That conviction, however, was later overturned after an appeals court ruled that jurors had received incorrect legal instructions, allowing the case to be retried. Several years later, the case returned to court for a second trial. Prosecutors again argued that Wade's actions led to McCoy's death, while the defense claimed the incident was unintentional.
And this is a tragedy, not a crime, which he will live with the absolute rest of his life.
It was not an accident when during the course of an argument, this defendant drew that handgun from under the seat.
For McCoy's family, the retrial reopened old wounds, forcing them to relive the loss as they waited for another verdict.
The evidence that they showed and everything doesn't show that it was an accident. I mean, it's common sense.
I've been waiting for this for 6 years. I want him to understand and feel the pain that my family feel. You know, if he can understand how we feel.
After hearing the evidence, a new jury deliberated and ultimately found Wade guilty of second-degree murder once again, resulting in a lengthy prison sentence. A separate civil case later held Wade and others financially responsible, reinforcing the lasting impact of McCoy's death on her loved ones and the community. Otis Anderson Sr. was involved in a tragic family incident in late 2021 that began with a disagreement at his Jacksonville home. The situation reportedly started over a minor issue involving a dog and escalated into a heated argument between Anderson Sr. and his son, Otis Anderson Jr., a well-known former college football player. Law enforcement was called to the home that night, where Anderson Jr. was found critically injured and later died. Anderson Sr.'s wife was also injured during the incident. In the days that followed, Anderson Sr. was arrested and charged with second-degree murder and attempted second-degree murder. He entered a not guilty plea.
The defendant does not have to say anything. There's nothing more he can say than he's not guilty. It is up to the state of Florida to prove this case beyond a reasonable doubt or make a determination that it's appropriate to work out some sort of plea arrangement for the defendant, and the defendant would have to agree to that.
Over the next 2 years, the case moved through the court system. In 2023, prosecutors and the defense reached a plea agreement that reduced the charges to manslaughter and attempted manslaughter. A judge sentenced Anderson Sr. to 12.5 years in state prison with additional probation to follow. Amber Whited was a 22-year-old mother of two from Brunswick, Georgia, who disappeared in mid-July 2013 after leaving work for her lunch break. When she failed to return, her family reported her missing, and police began searching. The next day, her car was discovered abandoned with a flat tires and the keys still inside, deepening concerns about her safety. Several days later, investigators found a body in a wooded area off Bladen Road. As the investigation progressed, authorities identified Raymond Michael Braziel, a 20-year-old man from Waynesville, Georgia, as a person of interest. People who knew him described him as normally calm and friendly, saying his alleged actions were hard to understand.
Regular country guy, you know, just a young boy getting a start in life, and I mean, usually he's happy. I don't think I've ever seen him upset.
When was the last time you saw Braziel?
Thursday afternoon. He come up to my mother's house and was talking to us, and he had on his arms and on the side of his face. And my mother asked how he got him. He said that he was walking in Brunswick looking for a job, got too hot, and passed out on the sidewalk. It's just unbelievable that somebody that I knew I hugged his neck just Thursday evening could do something like that.
While detectives continued working on Whited's case, Braziel was also linked to a separate incident involving a Glynn County couple. He was taken into custody and charged in that case, and a judge denied him bond. The legal process concluded when Braziel entered a guilty but mentally ill plea related to multiple deaths from that period, bringing an end to the criminal proceedings. Dolores Futrell was a 65-year-old Jacksonville resident who was found in her home in August 2008. Investigators later arrested her neighbor, Randall Deviney, who was 18 at the time, and charged him with her murder. In 2010, a jury found Deviney guilty, and a judge imposed a death sentence. That sentence was later overturned on appeal after a court ruled investigators had violated Deviney's legal rights during questioning, sending the case back through the court system. Deviney was retried. During the court hearings, Futrell's daughter and sister shared heartfelt statements about how her loss changed their lives.
To let you know what kind of person she was in life and how losing her has impacted my life. I can tell you that she was my mother, she was my sister, she was my friend, and she was my support not only to me and my children, but also to my friends, my military family, and to the neighborhood.
A second jury again found him guilty and recommended the death penalty, though the vote was not unanimous. After Florida law changed to require unanimous jury agreement for a death sentence, Deviney faced another sentencing phase. In 2017, a new jury unanimously recommended the death penalty, and in 2021, the Florida Supreme Court upheld that sentence. Deborah A. Collier came under investigation after authorities were alerted to concerns involving her and her disabled great-granddaughter. Deputies began searching for Collier after family members discovered a typed note that raised serious safety concerns. Later that day, law enforcement located her vehicle and conducted a welfare check. Inside the car, deputies found the girl unresponsive but breathing. The girl, who is nonverbal, has mobility limitations, and requires constant care, was immediately taken to the hospital for treatment. Collier's neighbor, whose son is autistic ICC, had this to say.
You hear her screaming all the time, and not from like being hurt, but just like the vocal stemming. My son does it too. I feel so bad for her because she's probably going to spend like the rest of her life in jail, and now her biggest fear is her reality now. As the years progress, it's always new challenges, but it does get better. You're not alone.
Investigators said they found prescription medication and another note indicating Collier was overwhelmed by long-term caregiving responsibilities and feared placing the girl in a full-time care facility. Authorities believe deputies intervened before the situation became fatal.
The court is going to currently set no bond in this matter. And if at a future point a bond is set, the court is issuing a specific order ordering you to have no contact with the alleged victim in this case.
Collier was arrested and charged with attempted first-degree murder, and a judge ordered that she be held without bond and have no contact with the girl. The case has sparked conversations in the community about caregiver stress and the importance of seeking support before reaching a crisis point. Jose Antonio Maldonado Sr., was arrested in May 2016 following the death of his former girlfriend, Linnie Chris Drum, in Palatka, Florida. The two had been in a long-term relationship and shared a son, who was already an adult at the time. Court records show Drum had previously obtained a legal injunction against Maldonado, indicating ongoing personal conflict. Authorities say the incident occurred outside the Putnam County Health Department, after which Maldonado left the area, but later turned himself in at the Putnam County Jail. The area was briefly secured while police investigated. In the years that followed, Maldonado remained in custody as the case moved through the court system. Instead of proceeding to a lengthy trial, he later entered a guilty plea to first-degree murder. In 2018, a judge sentenced him to life in prison, formally closing the criminal case. Prosecutors cited both the seriousness of the offense and Maldonado's prior criminal history during sentencing. Francisco Portillo Fuentes became involved in a tragic chain of events in November 2016 in Yulee, Florida. That day, a U.S. Border Patrol agent approached a group of men at a gas station. During the interaction, some of the men acknowledged they were in the country without legal status. At that point, Portillo Fuentes ran from the scene. Nassau County deputies responded and attempted to locate him. During the search, Eric Oliver, a deputy with the Nassau County Sheriff's Office, was struck by a passing vehicle while responding and later died from his injuries. Portillo Fuentes was arrested later that day following a multi-agency search. He was charged in connection with the deputy's death, and his case moved through the court system over several years. In 2021, Portillo Fuentes pleaded guilty to aggravated manslaughter. A judge sentenced him to 12 years in Florida State Prison, bringing the criminal case to a close, according to the State Attorney's Office for Florida's 4th Judicial Circuit. Prince Holland was a boy from Jacksonville whose death in December 2022 led to a major criminal case. He was riding in a vehicle after football activities when shots struck the car, taking his life and leaving others hurt nearby. Police launched an investigation and later arrested 2 men they believed were responsible, Contrevious Garrard and Marcel Johnson. Both were charged in connection with Holland's death, and the court decided their cases would be handled separately. Garrard testified in his own defense, and his attorneys argued that the evidence did not clearly place him at the center of the crime. After deliberations in October 2025, the jury found Garrard not guilty on all 5 counts, clearing him of the charges and leading to his release.
State of Florida versus Contrevious Tyree Garrard. Verdict count 1. We, the jury, find the defendant not guilty. Verdict count 2. We, the jury, find the defendant not guilty. Verdict count 3. We, the jury, find the defendant not guilty. Verdict count 4. We, the jury, find the defendant not guilty. Verdict count 5. We, the jury, find the defendant not guilty. Juror number 1, are these your true and correct verdicts? Juror number 2, are these your true and correct verdicts? Juror number 3, are these your true and correct verdicts? Juror number 4, are these your true and correct verdicts? Juror number 5, are these your true and correct verdicts? Juror number 6, are these your true and correct verdicts? Yes. Juror number 7, are these your true and correct verdicts? Yes. Juror number 8, are these your true and correct verdicts? Yes. Juror number 9, are these your true and correct verdicts? Juror number 10, are these your true and correct verdicts? Juror number 11, are these your true and correct verdicts? Juror number 12, are these your true and correct verdicts? Yes.
In Johnson's case, jurors were unable to reach a unanimous decision, resulting in a mistrial. Prosecutors later said they would review whether to retry him. Following the verdicts, Holland's family spoke publicly about the lasting pain of losing their son and reliving the case in court. Kira Addison was a girl from Jacksonville who had just started school. She lost her life in April 2020. She was sitting in a car with family members outside a convenience store on the city's north side when a disagreement between adults nearby escalated. Police said the dispute was over money, and Kira was struck while still inside the vehicle. She later died from her injuries, devastating her family and the community.
She was a little girl that loved to smile. Every time I came to the house to see her, she was smiling. Just like school, she seen me and she ran up to me and hugged me and smiled. It felt great. Jessica did an awesome job. Jessica having served, we're gonna miss her. And she was my heart. And I wish he was still here.
Investigators quickly identified multiple adults connected to the incident and arrested Tierra Beaufort, Jonathan Hall, Adrian Covington, and Tom Everett Jr. As the cases moved through court, charges were reviewed and adjusted. By 2022, sentencing hearings concluded, with judges imposing life and other lengthy prison sentences on those held responsible. These rulings brought an end to years of legal proceedings, as Kira's family continued to honor her memory and the joy she brought to those who knew her. Marla Eileen DeAndrea became the focus of a criminal case in June 2017 after authorities responded to concerns at an apartment in Jacksonville Beach, Florida. Inside, they found her mother, who was 67 years old. Marla later left the area with her son and was located by police at Orlando International Airport, where she was taken into custody. She was charged in connection with her mother's death and remained in jail as the case moved forward. As court proceedings continued, Marla underwent multiple psychiatric evaluations. Doctors determined that she was suffering from severe, untreated mental illness at the time of the incident. Family members were present in court during the ruling, expressing grief, anger, and heartbreak over the loss, while also acknowledging Marla's long-standing mental health struggles.
This did not need to happen. This could have easily been prevented. My mom should be alive.
Based on those medical findings, a judge ruled in 2019 that Marla was not guilty by reason of insanity. The court ordered her committed to a secure state mental health facility for treatment and supervision. Inside a family home in the town of Geneva, Wisconsin, where a boy, Michael, was staying with relatives. The visit was meant to be Michael was spending time playing games and enjoying himself in a place where he felt safe and trusted the adults around him. During the visit, Merkel handled a weapon inside the home. He later admitted the weapon could not discharge and did not expect it to function the way it did. In a moment of judgment, the weapon went off. Michael was critically injured. Realizing what had happened, Merkel contacted family members and then called emergency services. First responders attempted to provide help, but Michael did not survive his injuries. The loss deeply affected everyone involved and immediately triggered a criminal investigation. Law enforcement Merkel at the scene. He cooperated with others and acknowledged his role in the incident. Investigators Michael's death was not intentional, but resulted from extremely reckless behavior involving a dangerous weapon. Merkel was taken into custody and formally charged with first-degree reckless homicide, along with a penalty to firearm use. As the case moved through, Merkel chose not to go to trial. He entered a guilty plea, accepting responsibility and sparing Michael's family from reliving the events before a jury. A presentence investigation was ordered, and written statements from family members were submitted, describing Michael's life, his personality, and the impact of his loss. At the sentencing hearing, the courtroom heard from Michael's family, who spoke about the joy brought into their lives and the lasting pain left behind. Merkel's daughter that Michael was an innocent young person who trusted an adult in a position of responsibility, and that the tragedy was preventable. The defense highlighted,
Mr. Wiedenfeld, it's my understanding there is no limit to your argument or recommendation today, correct?
Correct.
Your position.
The defendant has no respect for human life, and he just seems to lack that natural instinct that people have to protect children. He shot and killed 8-year-old Michael. And I just wanted to put up, this is Exhibit 1, some of those pictures that we just looked at. And I wanted to put with it Exhibit 2, because that's the firearm that the defendant used to kill Michael. He took that gun, he removed the magazine from it, then pointed it at Michael and pulled the trigger. And it sounds like he did that because he thought it would be funny to scare him. And I don't know who lacks that basic instinct to not feel comfortable, to feel uncomfortable pointing a firearm at a child. But in the defendant's mind, that was funny. That was something that was a joke. And what he did was so reckless and careless, it's made the community outraged. And I think careless is a good word to use here, because really what he did demonstrates how little he cared for Michael. Michael was a great kid, liked sports, video games, had great friends, just a normal 8-year-old kid. And Michael looked up to Stephen, trusted Stephen, and so did Michael's mom and grandma. They all trusted him. The weekend of the shooting, Michael had been staying with grandma at her house. They went shopping, he bought a skateboard, they were having a good time, and Michael wanted to spend the night at the defendant's house because it would be fun. He'd get to stay up late, he'd get to play video games, he'd get to do all those things that an 8-year-old wants to do. And that's what he got to do. Around 1:51 in the morning of January 20th, Grandma calls and speaks to Michael, says, hey, it's late, you need to be getting to bed, it's early morning, stop playing the video games. And sometime between that phone call and when the defendant called Grandma, wanted to get the time. At 2:24 a.m., the defendant decided that it would be funny to do a few things. First, what he told law enforcement is that he got out a and that he was popping it at Michael, making it make that zapping noise, and that Michael was wiggling away. And I'm not saying he was doing this to be mean or cruel. I think this was something he thought was funny, to kind of scare Michael, and Michael would move away and try to get away, and he was doing it. Then the defendant said that he went and got the firearm, and that he took the magazine out, that he was under the mistaken belief that if you took that out that it couldn't fire, doesn't bother to check to see that there's a round in the chamber. And then the firearm was in his bedroom. He walks out of his bedroom where Michael is just sitting with a tablet on a couch and points the firearm at him and pulls the trigger. Michael had 2 wounds on his body as a result of that bullet. He had an entrance wound on his shoulder near the outside, and an exit wound kind of on the inside of his arm. And then he had an entrance wound near the center of his neck, and an exit wound near the back of his neck. That's consistent with Michael holding up his arm to feeling scared.
So it was one shot?
Yes. The defendant said that he had shown Michael his gun other times. He said that he would do it in a joking way, where he'd point it at the ground and tell him that he had to listen. Michael didn't die right away from the gunshot wound, and the defendant didn't call 911 right away. What the defendant told law enforcement is that after the shooting, he said, I looked at him and I seen the stress on his face, and he put his hand up and coming down, and I grabbed him and said, let's go to the bathroom. And that's consistent with what was observed in the house, is he took Michael from that couch through the living room, through the dining area, and into a bathroom in the residence. And I do have just an image of that bathroom. I'm not going to put that up on the overhead, but it's marked as Exhibit 3 that I can provide the court as well.
For the record, are you also asking that I receive Exhibit 2?
Yes, please.
Any objection to the court receiving Exhibit 2?
No objection, Your Honor.
Exhibit 3?
No objection.
Both are received.
And one was part of the original packet, but I'd ask the court to receive that as well.
Received.
The defendant told law enforcement that he grabbed him and said, "Let's go to the bathroom." The defendant then said that toilet paper isn't the best thing to plug a hole. So I called Grandma, and she said to call 911. We know that the call to Grandma was at 2:24 a.m., and then the call to 911 was at 2:25 a.m. The defendant in the PSI and to law enforcement says that he has medical training. Despite that medical training, he moved Michael through the house, leaving a trail of blood, and then apparently tried to stop the wound with toilet paper in the bathroom. The firearm that was used was located in the bathroom, so he took the firearm with him during this. It's not exactly clear why. And then he called from the bathroom the grandmother, and 911. Officers arrived at 2:28 a.m., so about 3 minutes after that call came in. At that time, Michael was still breathing. They were trying life-saving measures on him. The dispatcher, or the 911 recording, did record some faint moans at the time that call took place. But as law enforcement was trying life-saving measures on Michael, they did lose a pulse and he did stop breathing. He was carried out by officers to an ambulance and driven to the hospital. Shortly after arriving at the hospital is when he was pronounced. The defendant was 52 years old at the time that he shot Michael, who was 8. The defendant had a concealed carry permit. He had taken classes on how to safely handle a firearm. He knew that it was dangerous to point a firearm at somebody. He knew that he should have cleared the firearm. He knew that he never should have pointed it at a child or another person. And these were his bad choices. There was some alcohol in his system. He had shown a few signs of impairment to law enforcement. He agreed to provide a blood sample. A blood draw took place at 3:29 a.m., so that's about an hour after the shooting. And the result of that is a .02. So it's not that he was highly intoxicated and this was something that was driven by alcohol or that he just lacked any sort of ability to use good judgment. He made bad, reckless, careless choices. The defendant has a record that's described in the pre-sentence investigation report. I recognize that most of that is from the 90s and 2000. It includes DUI offenses, domestic violence, thefts. There's an unlawful use of a weapon charge in 1994 where he described that he had possessed a gun when he wasn't supposed to. And I point that out not because I realize that there's a time gap between those and what happened here, but he had interventions in terms of his own personal history, and he had opportunities to address his vices or his personality issues, but nothing changed. Defendant was cooperative with the investigation. He admitted to shooting the victim. He admitted it in the 911 call. He admitted it to law enforcement, and he pled guilty without having a trial. So I do think he's accepted responsibility for what he did. There's been no real efforts to minimize, other than perhaps some statements about that he didn't really think he was pointing it at Michael, just near Michael, or things like that. But for the most part, the defendant's accepted responsibility for what he did. This is a serious offense. And in terms of a reckless homicide, this is about as serious as the facts can get. This isn't a homicide where an adult chose to get in a vehicle with a drunk driver and then there was a fatal crash, and that victim, although it's not their fault, they made some choices that contributed to their death. Michael was a pure, innocent 8-year-old boy who just wanted to play some video games and have fun. And this isn't a drug overdose situation where someone was a drug user and had an addiction that contributed to their death. Again, Michael was trusting. He trusted the defendant. He wanted to be with the defendant because he thought it would be fun. The defendant knows how to use a gun properly, and he's the one who chose to use it in this reckless manner to try to scare Michael, to try to be cool. And he did that to a boy who trusted him and respected him and was following the rules that the defendant laid out for him. When I think about the seriousness, I think the fact that Michael's death wasn't instant is also an aggravating factor. When I think about these cases, I think about what Michael was thinking in those minutes before he died. He'd been betrayed by someone he trusted. He was probably scared, in pain, probably thinking that it was cold as he was laying on the bathroom floor. And someone who he was trusting to help him moved him into that bathroom and was trying to put toilet paper on the wound before calling 911 for help. The only real mitigating factor in this case is the defendant was honest about what happened and has accepted responsibility for his actions. And in evaluating the seriousness, it's hard to craft a sentence that's consistent with it. Michael had a full life ahead of him. If he lives to be 70 or 80 or older, that's more years than we even have available as a maximum sentence. And all that time, all of that life that Michael had to live, all those positive effects that he would have had on his family and the people around him, all of that was stolen by the defendant and his reckless, careless actions. And those actions didn't just harm Michael, they harmed others as well. Law enforcement and medical staff had to respond to this gruesome scene trying to revive a seriously, critically injured child. We've heard from Michael's mother and in the victim impact statements from other family members feeling guilty. They're blaming themselves just for giving the defendant access to them. But there was no way to know that he was going to do this because they have an instinct that would protect a child. They understand that it would make no sense for somebody to point a firearm at a child and pull the trigger. They have something that the defendant lacks, and they just didn't know that he lacked that ability. Michael had 8-year-old friends in school who had to learn about death at a young age, who attended a funeral, who had a counselor in their classroom to help them get through this. And that's what the defendant did when committing this crime. This is the type of crime that squeezes the happiness out of a community and leaves everyone feeling empty and sad. In terms of the defendant's character, I think the crime here fits his character. I think he's reckless, and I think he's careless. And I think he lacks that instinct to protect children. Pointing a gun at a young child is something that should make somebody's skin crawl, and just the idea of it should make them feel uncomfortable. And the defendant's doing this in a joking manner and laughing. In terms of his character, the defendant in the PSI and in his own sentencing memo talks about his history and having a bad childhood, having medical issues, having a death of a loved one in the last year before this offense. And the problem that I have with that is that somebody who goes through those experiences should come out feeling more protective of kids and should come out feeling more protective of life. And I don't think that it really explains this behavior. There's no explanation for this behavior other than just it's who he is and it's the bad choices that he made. In terms of his character, the defendant's comment to the PSI writer about what he would do if he's released is he said that he would play video games and eat good food. He doesn't talk about going back to the community to try to help people heal. He doesn't talk about trying to live a life that makes up for the loss that he's caused. He focuses on himself. And I think that's consistent with what his personality demonstrated in this offense. And that's why there is a need to protect the public from the defendant. Because how do you keep people safe from someone who just lacks that basic human instinct or emotion to protect life? I don't think this is a situation where if you take away the guns and you take away alcohol, that the problem's solved. Because this is a deeper issue than that. I don't know how you teach someone to care about others more than themselves. I also think that this is the type of case that calls for deterrence of others. Firearms are dangerous, and people know that. But it's also important for people to understand that when they are reckless and careless, and when they kill people for no reason, that there's going to be serious consequences. And that's something, regardless of where people fall on the political spectrum, whether you're pro-firearm, anti-firearm, nobody thinks that what the defendant did is right or okay, or that he should have had a firearm that day.
Remorse, his cooperation with authorities, and the fact that there was intent to cause harm. Merkel briefly sport himself, apologizing to Mike's family, and accepting responsibility for his actions. After reviewing...
Mr. Merkel, you have the right to address the court. Is there anything you would like to say today?
Yeah, first off, I'm here to accept responsibility for my actions in this tragedy. I'd like to apologize to the court as well as to the victims affected in this tragedy.
Anything else you would like to say?
Not at this time, Your Honor.
In statements, the judge described the case as heartbreaking and entirely avoidable. While acknowledging remorse, the court stressed the seriousness of the offense, the breach of trust, the need to protect the public. Stephen Merkel.
The court is torn as to whether or not an objective of its sentence today is rehabilitation of the defendant. Because the court shares the state's concerns, what is there here to be rehabilitated? This was a reckless choice that no one in their right mind would have ever thought would happen. How do you rehabilitate someone from making those kinds of choices? Someone who is a full-grown adult, 52 years old when this happened, with an education, a background having been trained as an EMT, having training in surgical technology, and having been through a concealed carry class with regard to firearm safety. What more is there to be rehabilitated that weren't already in his skill set to prevent this from happening again? Or is the objective of the court rehabilitation in terms of, as kind of mentioned by the defense here, counseling to help him live with what he has done? When I look at the crime here, and make no bones about it, this was a crime. First-degree reckless homicide. This wasn't an accident. This wasn't a mistake. I'm not sure if it was in the PSI or the defense memorandum. I think it was actually in both. The defendant referring to this as an accident, a freak accident. A freak accident is something that is not preventable. That is not what this is. This was entirely preventable. This was the result of reckless choices, a series of them. The defendant told police, and I'm getting this information from the PSI, Stephen stated that he showed Michael the guns because it made him look cool. That's one of those things that it's impossible to wrap one's head around. A 52-year-old at 2 o'clock in the morning, roughly, pulling out firearms to look cool to an 8-year-old. I know that alcohol was involved, although there's no indication here that he was impaired to the point of intoxication. About an hour and a half, roughly, if my times are right, after his blood alcohol level was a 0.02. He admitted to having 2 rum and coke drinks that night after Michael's grandmother left the house, so after 10 p.m. Sitting around playing video games with an 8-year-old, but you needed to drink? Maybe that's where the rehabilitative needs are. But there's no indication that you were intoxicated. The PSI goes on to state that you told police. He stated that he showed Michael a stun that he had at the residence and was, quote, popping it, end quote, and pointing it towards him while he was squirming away. A stun is still a weapon. How is that fun? The defendant then went to his bedroom, took out a 9mm handgun, and took the magazine out of the gun. He did not believe the gun would fire without the magazine in it. He reported he walked out of the bedroom, pointed the gun at Michael, and pulled the trigger, expecting it to click, but instead it went, quote, boom, end quote, Michael. He stated that he was trying to be, quote, cool and exciting, end quote, for Michael. How is it cool and exciting to point a gun at an 8-year-old boy? Today's the first that the court learned that the bullet went in through Michael's upper arm or shoulder area, came out, then passed through his neck. That's a defensive posture. How is that fun and cool for Michael that you come out of a bedroom pointing a gun at him to the point where he's scared? He puts up a defensive arm and you shoot him. How is that fun? How does that make you look cool? You were asked if you had ever taken a hunter's safety or concealed carry class, to which you said yes. When asked if you had ever pulled a weapon on anyone before in a joking manner, you said, quote, I might have done, strike that, quote, I might have before with Michael, but that would be with, you know, the gun I usually carry concealed, end quote. You then mimicked how you would do it before with Michael, with police. You mimicked drawing a pistol and pointing it toward the ground. You said you would do this to get them to listen fast. And when asked by officers if you thought that was a good idea, you said probably not. You told the PSI writer and this is different than what you told police. You told the PSI writer you asked Michael if he wanted to see the gun and learn more safety. One of the first things that's taught with gun safety is you never, ever point it at someone. You never goof around with guns. Yet you tell the PSI writer you wanted to show Michael gun safety. That's not what you did. Mikey said yes to wanting to know more about gun safety. So you unlocked your safe with the firearm. You removed the clip from the gun and went to show Mikey the gun. The gun fired and you lowered the gun and saw a hole in Mikey's neck. And you admitted in your independent memorandum to the court that you pointed it at him and pulled the trigger. When they searched your residence, they found 268 rounds of ammunition in various sizes and brands. You had inside your home a shotgun, a full-sized 9mm handgun, and a Smith & Wesson handgun. Apparently you also had that gun in the house. There are three primary sentencing factors that the court is to consider when weighing an appropriate sentence: the need to protect the public, the gravity of your offense, and your character and rehabilitative needs. Clearly, through the court's recitation of what happened that night, this is a serious offense. They don't get more serious, other than if this had been intentional. And there's no indication that it was. Not at all. It was reckless. But it was based on choices that you made. Again, the protection of the public is a paramount consideration of the court, and your character and rehabilitative needs. In weighing these factors, the court looks at a number of considerations. Your prior record. The prior record is listed in the PSI. It's been touched on by the state. Although you haven't had any criminal convictions in roughly 20-plus years. You do have priors before that, everything from thefts to OWIs, domestic battery. There's that unlawful use of a weapon charge from 1994, which is concerning to the court. You've been on supervision before. I am to consider if you have a history of undesirable behavior. In the PSI, it talks a bit about your history of a variety of different type of drug use. Apparently, it's been several years since you have used controlled substances. I am concerned there might be an alcohol problem here based on the DWIs in your past and the fact, as I've already said, that you were drinking this night, although not to the point of intoxication. I am to consider your personality, character, and social traits. I know that you have some mental health diagnoses for which you have received treatment in the past. I know that you had what seems to have been a difficult childhood. From the age of 17 until she passed, your age 17 until she passed, you did not have a relationship with your mother. Your biological father died when you were very young. There are contradictory indicators from the PSI versus the defense's sentencing memorandum with regard to your relationship with your stepfather. But it seems that you did have a difficult childhood. At one point, you were in a gang. Because of your involvement in that gang, you were attacked. You were almost killed. You suffered a TBI. That was at the age of 14. However, you still, although you dropped out of high school, you got your GED. You took college classes, including a certification as an EMT. You got a certification in a surgical technology program. You've had numerous short-term jobs over the course of your life. You currently are on disability. You married Michael's mother in 1995 and apparently were never divorced, although you separated and have been separated for a number of years. Michael's mother had Michael and her other daughter with Michael's father. You have one child with Michael's mother, and she spoke here today. And the court's heart, of course, goes out to her, the incredibly difficult situation that she is in here today. And I want to be clear. The court does not think that the defendant here is a monster. I certainly have seen persons come through criminal court who I would describe as evil to the core. That is not you, Mr. Merkel. I believe that you are remorseful. I believe that you would trade places with Michael if you could. You are here because of the unbelievable choices that you made that night. And the court looks at you as an entire person in deciding what's the appropriate sentence here today. I know that your daughter is your sole child. She has 2 young children who are your grandchildren that you are close to. I know that you had a long-term girlfriend who passed away recently before this happened. According to the PSI, you have friends and seemed satisfied with your life. I am to consider if this is a vicious or aggravated crime. The court considers this to be aggravated. Showing off to look cool by getting out a gun and pointing it at an 8-year-old and pulling the trigger when this was not the first time you were messing around with in front of him. Aggravated, especially when you are in a position of trust over this boy. His mother, his grandmother trusted that you would take care of him. Instead, the absolute insanity of your choices that night, it's appropriately charged. Recklessly knowing the danger and showing utter disregard for human life, you made the choice to do that, to look cool. Your degree of culpability is 100%, and to your credit, you told the police what happened. As I've already stated, there's been some variations in terms of what you were actually doing that night. Were you showing Michael how to safely handle a gun, or were you just trying to look cool? But regardless, you did call 911. You did confess, and you pled guilty as charged, recognizing what you did and sparing the family of a trial. I recognize that. Your demeanor in court has always been good. You are now 53 years old. I've noted your educational background, your employment history here, and what I believe to be a sincere statement of remorse. Although calling it an accident, as I've already stated, I disagree with. Your need for close rehabilitative control is incredibly high. Again, because who would have ever guessed that you would make a choice like this? But you did. And that means the community is at risk, because what kinds of other choices could you make? The rights of the public here, as I've already said, are paramount to be safe from your reckless behavior and your disregard of the incredible risk involved with guns. This was real life. This was not a video game. You have been detained since you shot Michael. I've already noted the aggravating factors here. The mitigating factor is, again, that you confessed and you have pled guilty. Obviously, this is not a probation case. Absolutely, confinement is needed to protect the public, and probation would unduly depreciate the seriousness of the offense. When I weigh the 3 sentencing factors, consider the court's objectives, and all of the considerations here today, I am sentencing you as follows: 25 years of initial confinement, followed by 10 years of extended supervision. I absolutely think that this is the minimum amount of confinement and custody consistent with the sentencing factors as I have weighed them here today. I am adopting the recommendations for extended supervision as stated by the district attorney. He is not statutorily eligible for the challenge incarceration program, nor for the earned release or substance abuse program. It was evident to the court today, listening to Michael's mother talk about what a wonderful young boy he was. I sincerely hope that your memories, the family's memories of who he was and the time that you did have with him are a comfort to you.
To 25 years of initial confinement followed by 10 years of extended supervision. The judge stated that this reflected the gravity of the loss and the responsibility that comes with handling dangerous weapons. The case concluded in, but for Michael's family, the impact of that day was permanent. Joseph Schroer's big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.